Legal 116, this is your podcast for week number 10. This week, we're going to talk about answers and the things that go with answers to a complaint, affirmative defenses, etc. I asked you to do some reading. If you haven't done the reading, please do the reading, because what I'm going to say isn't going to make sense if you haven't done the reading. Always in conjunction with the podcast is the reading, and they go hand in hand. And some of you found that out when you tried to skip all of the listening and reading expected and exactly what I provided on the complaint. So we've had our complaints. You'll have responses to your motions to dismiss. After you get the amended complaint, what happens is you have to respond to it. If you had a complaint that wasn't subject to a motion to dismiss, you would have responded to that complaint. Under the Illinois Code of Civil Procedure, the answer is the pleading in which the defendant responds to each allegation of the complaint by either admitting it, denying it, or indicating the inability to admit or deny the allegations in the complaint. And you just go paragraph by paragraph. So if it's a one-count complaint, the answer to those first few paragraphs where you're essentially setting out the scene, the parties, the location, the date, the time, and generally what occurred before you get into the duty, most of those things are going to be admitted, and it would be essentially as easy as defendant admits the allegations contained in paragraph 1 of plaintiff's complaint, and so on. You're only going to deny when it's something that's going to be in dispute. And in a case like ours, the things that will always be in dispute will be how the accident occurred, the negligence, and then the damages. So everything after you have the duty allegation would likely be denied. And it would simply be defendant denies, for instance, the negligence paragraph that had the sub-paragraphs. Defendant denies all allegations contained in paragraph, let's say it was paragraph 6 of plaintiff's complaint, including paragraph 6A, B, C, D, and E. The answer will also include affirmative defenses that the defendant wishes to assert, as well as any applicable counterclaim or cross-claim. And you may remember discussion about counterclaims and cross-claims when we talked about complaints. And if you don't, go back and review those materials. An amended pleading is a pleading filed that alters the allegations and or responses of an earlier pleading based on something other than newly occurring transactions. A supplemental pleading, as that term is used, is a pleading that modifies an earlier pleading based on transactions or occurrences taking place subsequent to that earlier pleading. So things that happen after the date of the initial, whatever that would be. Those typically come up in contract or business type transactional causes of action, not in negligence causes of action. Negligence causes of action, negligence happens, and that's it. And that's what we're fighting about. A revised pleading is a term used in the practice of some state courts, and it can refer to an amended or a supplemental pleading. But typically, you have one of those two. And all of you are likely going to have an amended complaint because your first complaint needed some work and was subject to a motion to dismiss. The term affirmative defense in a civil lawsuit or a criminal charge, for that matter, is a fact or set of facts other than those alleged by the plaintiff or the prosecutor, which, if proven by the defendant, defeats or at least mitigates the legal consequences of the defendant's otherwise unlawful conduct. Now, affirmative defenses don't come up often. In the criminal sense, it would be, for instance, self-defense to a battery charge. Those of you who had criminal law and we talked about defenses, you'll remember affirmative defense of self-defense comes up occasionally when you have that battery type situation. In the negligence arena that we are focused on in our case, affirmative defenses are not as prevalent, but most of the time what they're going to allege is within the fact scenario that we're dealing with, there was some sort of contributory negligence, some sort of other act by the plaintiff that contributed to that accident. So in our case, as an example, if our client had been speeding or allegedly speeding or driving erratically or crossing the center line or had stopped and waved the other driver in, although that's kind of a weak affirmative defense, as you know from what you have read about the duty to yield the right-of-way. But something like that. And remember, that's probably something that the defendant might raise because that's what they said, right? That was one of the little facts. And again, those are facts that we saw so far in the investigation. We have not investigated fully with discovery, which we will get into in the coming weeks. But those are affirmative defenses. I don't think we're going to worry about affirmative defenses in our case. Section 2-613, as you may recall, requires separate counts and defenses, just like we require separate counts and allegations. Parties may plead as many causes of action, counterclaims, defenses, and matters in a reply as they may have, and each shall be separately designated and numbered, just like we were required to do in the complaint. So yada, yada, yada. It's the same. The facts constituting an affirmative defense, such as payment, release of satisfaction, discharge, license, fraud, duress, estoppel, laches, statute of frauds, illegality, that the negligence complained of was contributed in whole or part by the injured party, by the plaintiff, that the instrument or transactions either void or voidable in point of law or can't be recovered upon by reason of a statute or reason of non-delivery, want or failure of consideration, some sort of contract failure, or other affirmative matter. You know, all those things that are listed need to be separated out. And they have to be set forth in the answer or reply, so you bring those up at the time that you are answering the complaint. I won't go into the common defenses. I hope that you read about those. I hope that you have looked at the statute. I'll probably write something about those when I post my response later. But for this week, it's important that you get into the Illinois Code of Civil Procedure section, that you look at the ICL and review information about answers to civil complaints, affirmative defenses in civil cases, and you look at the Supreme Court rules that apply to answers. Remember, we have our Code of Civil Procedure and our Supreme Court rules. We have the what and the how we're supposed to do something. So use those things and get used to using those things, because if you get in trouble for not following the law, it will likely be because you have not done that. And if you have something like ICL available, which many of you say if you're working in civil litigation, you likely have the ICL on civil litigation available to you in your office, use those things. They provide you with all the guidance you need. So next week, if you've done a good deal of work creating your base about answers, you're going to be in good shape, because by next week you will have your answer on the motion to dismiss, and you will have your direction to file your amended complaint. And then, barring someone completely on the second attempt failing to do what they should have done to the greatest degree on the first attempt and only having to make a few changes, so their second attempt is perfect, which is a lot of you are going to end up in that situation, but some of you are going to end up with a lot more work, and I've suggested that you do that work ahead of time, and hopefully you have. As we move into next week, you are going to file an answer. You're going to create an answer to the amended complaint. Instead of a motion to dismiss, as the defendant, whoever you file the motion to dismiss against, you are going to draft an answer to their amended complaint. So do the work this week. Review the things I told you to review. Read the things I told you to review. Look at examples of answers. Remember the things I've said here. And don't make it more complicated than it might be. Okay? It's not that complicated. If you just remember the things that we've talked about for weeks now. These things are form. You're not arguing the facts to win the case. This is not where you prove the case. These are allegations. You are merely pleading and then answering, responding to what the allegations are, so that we can move forward to discovery in the weeks after next week. I appreciate the effort that most of you put in up to this point. I hope a few of you will get with it and put in a little higher effort as we move through week 10. If you need me, you know where to find me.